The title is Corporate Lawyers, Values, Institutional Logics and Ethics. Let me just dive into the text and we'll see where we go. US corporate scandals have often been followed, I think we heard this earlier, by the question, where were the lawyers? Whilst this is less so in the UK, recent events suggest we should ask that question more persistently and critically. Private practitioners and in-house lawyers had roles in serious wrongdoing by BNP Paribas and Standard Chartered Bank, and by the News of the World and the Times newspaper. Allen and Overy were accused of putting inappropriate pressure on a prosecution witness by a Crown Court judge, caused an aborted trial. Clifford Chance litigated a client's fraud case in a way found by a now Court of Appeal judge to be artificial and now I quote, replete with defects, illogicalities, and inherent improbabilities. Sounds a bit like a student essay. What they did, raised serious professional misconduct issues. I could go on, and I will. Evidence during a Russian oligarch's trial was polished. 2 former Barclays GCs have been interviewed under caution. In-house lawyers in General Motors, okay, this is in the States, have been in the spotlight for the way they dealt with fatal accident claims. Some banks were exposed recently for having a practice of sending letters from fake law firms. Within this group, several lawyers have been fired, many investigated, including some criminally, and some prosecuted by their regulators. In others, I believe actions are pending. A variety of explanations might be given for such cases. What I want to examine here is whether there are underlying flaws in the institutional logics applied to or by corporate lawyers. By corporate lawyers, I mean simply any lawyer whose clients or employers are predominantly corporations. By institutional logics, I speak perhaps a little glibly to a sociological hinterland which calls on the work of Daniel Muzio, James Falconbridge, and others. I'm particularly interested in the ideas that, and here I'm quoting from a piece by Muzio and several others, professions act as carriers of normative, coercive, and mimetic pressures. They repeat certain patterns. And in questioning the extent to which professionalism is, or could, or should be a restraint on unlawful risk-taking. Do professionals retain normative value besides their privileged market position, if indeed they still have a privileged market position? In this sense, I see an exploration of institutional logics as identifying what categories, principles, and conceptual tools lawyers use to define and frame issues, and in particular, what categories, tools, and principles lawyers use to define ethical issues. This involves engaging in how reflective they are about the practices they apply and how conscious or protective they are of their own agency, their own role in these processes. Similarly, Abbott's claims about a professional system being part of an ecology of other systems is of interest. To what extent are corporate lawyers part of a distinctive professional system constraining and contesting their position with others? Professional managers, risk specialists, compliance personnel, and the like. But in drawing on this sociological work, I want also to emphasise, Joan talked a bit about this, the growing importance of behavioural science. Findings on framing, priming biases, and the like provide a number of clues as to how different social systems may influence behaviour, sometimes subconsciously, and I want to begin the task of showing how some of that learning may also apply to that intellectually sophisticated being that is the corporate lawyer. A more ordinary but important way of putting the issue under examination is to claim that the practice of law is a business, not a profession, that old chestnut, that clients are too powerful, and that lawyers sometimes neglect their ethical obligations. I note also that the professional bodies have questioned the adequacy of education and training in the field of ethics. And again, I note the Legal Education and Training Review evidenced a really rather strong consensus within the professions, at least as surveyed, about the need for education in the area. Furthermore, and this is kind of where Stephen comes in, I note the general paucity of empirical study of professional ethics of commercial lawyers in England and Wales. There's just not been very much done. This is concerning given the importance of London as a centre for global business, and yet even in the United States, the literature concentrates mainly on in-house lawyers rather than private practitioners. Tonight I want to talk about both. In the UK, there's been John Flood's estimable work on globalisation, and Janine Griffiths-Baker's very interesting account of conflicts of interest, but not really much else, not much empirical work. Stephen Vaughan's work with Claire Coe on ways in which institutional clients may influence professional independence is coming, and you've heard a bit about some of his work. He had some really great quotes there. I was actually reeling a bit of professional jealousy. I wish I had those quotes. Today, though, I want to talk about 3 studies I'm involved in, relevant to this evening's look at institutional logics and the values of commercial lawyers. So in one study, Professional Minimalism it's called, I've done it with Victoria Hinchley, it's coming out in the JLS in December. We interviewed 21 generally very senior interviewees from elite practice. 12 were employed as in-house lawyers in large companies and public sector organisations, and 9 in very large or large private practice firms. Think Silver Circle or larger. A second study, authored with Stephen Vaughan, Legal Risk Definition, Management and Ethics, is based on interviews with 34 senior in-house lawyers and some senior compliance staff in large corporates and similarly complex organisations. The third study is actually a raft of studies. There isn't a publication yet. We're still working on this one. Takes the issue of values and looks at the influence of values on lawyers. In the one I'm going to talk about tonight, we look at a group of 100 elite lawyers from private practice and blue chip corporates, and we pose the question, might their values, their basic values, influence their ethical decision making? Indeed, what are their values? Okay, let me turn then to the things I think we learn from these studies. The professional minimalism study. The professional minimalism research asked lawyers how they understood ethics. We explored this through semi-structured questions, but also vignettes, ethical problems, to see how they approached ethical dilemmas. We reached the conclusion that the professional ethical consciousness of commercial lawyers, both in-house and in private practice, was minimalistic, and minimalistic in a number of ways. How so? Well, firstly, they said ethical issues occurred infrequently. It followed that they thought ethics was not much relevant to what they saw themselves as doing. Interviewees almost always distanced themselves from specific ethical problems. Other firms, clients, old employers, or other groups in the firm, so the young said the older lawyers might have problems, the partners said the associates had problems, were responsible. All the problems occurred years ago. Ethics was something that arose elsewhere at a distance for someone else. Secondly, there was a strong tendency to equate unethical conduct with criminal illegality. Our respondents leaned heavily on criminality and dishonesty in particular as determining the boundaries of what was acceptable. What is more, consistent with a view in the literature that professionals might bias towards risky conduct, some even emphasise the need to be knowingly involved in criminality or the need for conduct to be clearly criminal if it was to give rise to ethical concerns. Thirdly, ethical consciousness was minimal in the sense that there was relatively little discussion of professional principles or professional conduct rules. This was true when practitioners were asked to talk about ethics generally, but also when asked to deal with specific ethical dilemmas. Indeed, practitioners often did not discuss, still less dwell on, the professional conduct dimensions to any problem. There is a notable exception to this principle blindness. What could that principle be? Indeed, we heard today it was in their DNA. Yeah? It was, of course, the idea that the lawyer should pursue the client's best interests. This was recognised and emphasised by all. Many believed in the preeminence of this principle, a view contrary to the Solicitor and Bar's Code as it happens, and there was a hostility to the idea of the public interest and little, if any, mention of the public interest in the administration of justice, other than through the duty to the court. An interesting indication of how corporate logics can overlap with the professional client-first logic can be heard in this quote. I'm not going to show it, I'm just going to read it. Companies aren't in a position to have morals, they haven't got a soul, they are taking actually what are not moral or ethical decisions once you're outside the area where this is straight dishonesty. Note the modifier to dishonesty again. Now, this position is commercially and psychologically convenient for the participants, right? But its problems can be seen if we remember, for example, bank lawyers that sent letters from fake law firms. When this was exposed, I don't know how many of you followed this, the companies lined up to say they had acted entirely within the law, okay? Whilst beating a hasty retreat. We're not doing it anymore, but we were acting entirely within the law. Here we can see the claim. This claim was based, I think, on a claim that they hadn't breached the Business Names Act. So we found a bit of law that was relevant. We haven't breached that, therefore it's okay. Here we can see also how professional advice can be advice, but also a form of mutually assured irresponsibility. The lawyer says, you've not breached the Business Names Act, so as far as I'm aware, it's not unlawful. And the CEO feels they can then go on the Today programme and say they've acted entirely with the law. Note the shift from negative to positive to exaggerated. This brings us to our fourth ethical minimalism, the role of ambiguity. For our respondents, ambiguity was a shelter inhabited almost exclusively by that old friend, the client's best interests, or the business's best interests. It's possible to see, though, ambiguity is something which creates a space for ethical judgment. But this is not how most practitioners, especially private practitioners, I should say, saw it. For them, ambiguity diminished rather than heightened ethical relevance and played an important role, I think, in limiting their ethical consciousness. Deciding when, whether and how something is ambiguous, I would say, influences an individual lawyer's decision to say no, to advise against or to facilitate the exploitation of the law. Ambiguity may also influence how advice is shaped and presented. Consider the following description of how Standard Chartered Bank's lawyers appear to have advised their risk committee on its ill-fated wire stripping. Right, just by way of background, the bank wanted to clear payments from Iranian clients through US banks. Their internal lawyers advised it was probably almost definitely unlawful, and external advice supported that view very robustly indeed. Essentially, Standard Chartered Bank could not lawfully process Iranian payments without conducting due diligence on US soil. Yet they wanted to set up a speedy due diligence scheme outside the US to get the payments through quickly and to keep their clients happy, indeed, to keep their clients. They did this and then hid the Iranianness of the payments from the SCB, Standard Chartered Bank's offices in the United States. Okay, the US prosecutor quotes a bit of the apparent advice of a senior in-houser to SCB's risk committee, quoting, it seems, from an internal memoranda. It is reasonable to undertake due diligence on behalf of New York outside the US, the memo says, whilst also recognising we are potentially placing our SCB New York office and the bank at risk if our due diligence procedures are not fully effective. So the risk advice is all about effectiveness, yeah? As it happens, the procedures were not fully, or don't seem, at least certain people have certainly they've been criticised for not being fully effective in any event. But that's rather beside the point. It was not possible for the due diligence procedures of the type envisaged to be fully effective and lawful. It simply was not possible. The legal argument was not that it was lawful, but that the US regulators might not be able to enforce against the bank as long as the US office did not know that the transactions were Iranian transactions. Yeah, it was just about enforcement proofing. It was not about doing something that was either reasonable or lawful. The result, well, ambiguity in presentation and, I would argue, a monumental failure to protect the client's interest, the rule of law, and the public interest in the administration of justice. Professional ethical minimalism. The idea, indeed, of reasonableness used is an entirely self-serving commercial way to conceal illegality and perhaps, we cannot know, we weren't in the room, perhaps to mislead the risk committee. Ambiguity. Now, when we talked to our interviewees, active use of ambiguity sometimes gave them, especially in-house lawyers, a sense of discomfort about bending too strongly to their clients' imperatives. They comforted themselves with the view that they were their employer's agent. The business decided what constitutes acceptable risk, and the business, not the lawyers, were ethically responsible for sharp practices or other problems. Take this quote as an example of how an in-house lawyer saw their role. I'm going to read again. I always make sure that the client understands the law. I think they also need to understand what the law is trying to achieve so that if there is a grey area, they know the correct way to interpret it. They know the correct way. Note here, the lawyer is not even responsible for interpreting the law. Ultimately, the business is. Finally, I should reiterate that saying the approach is ethically minimalist is not the same as saying they are behaving unethically. The ethically minimalist position is consistent with a specific type of, if you like, zealous lawyering, doing all they can for their client unless the law clearly or very clearly prohibits them from doing otherwise. This isn't the place to rehearse all the arguments for and against zealous lawyer paradigms. The academics will be very familiar with those, but I would emphasise that professional rules and principles are supposed to act as a restraint on lawyerly zeal. A minimalist understanding of those rules and principles significantly weakens the impact of their restraint. To put it another way, all lawyers, be they in-houses or private practitioners, were very clear in seeing ethical problems not principally through the lens of professional principles, but through the social and economic lenses of business. They were conscious of business and of law, but they were not much conscious of ethics as defined by their own professional principles. In these ways, in fact, in-house lawyers and private practice were generally pretty similar. Let me now, though, concentrate on some areas of difference between those two groups. We cannot say from this kind of research, as it is often assumed, that in-house lawyers are more likely to be unethical than private practitioners. Our interview suggested in-house lawyers may be exposed more directly to the pressure to push the envelope of ambiguity, and the commercial and pragmatic influences of their organisations may well be stronger on in-house lawyers, but those pressures are far from weak influences on private practitioners, far from it. Conversely, interestingly I think, some in-houses also had a broader notion of ethicality than private practice. Other notions of fairness might enter into their decision-making through corporate codes and a culture of ethical leadership where they were in place and taken seriously. They said these kinds of things helped them take what they thought of as more ethical decisions. Equally, and conversely, private practitioners could plausibly claim greater independence. They could walk away from instructions or exit relationships more easily. They didn't often talk about examples of that, but they could do it. They too, but, and this is important, they too have their own particular de-ethicalizing tendencies. The traditional notion that a lawyer is not responsible for whether and how they advance a client's legally dubious case, coupled with the idea that they were often advising on more difficult, ambiguous questions, allowed them more leeway to discount any notion of ethics or public interest in their work. Something which I think might cut both ways was that in-houses' qualms about ethics were stronger than private practitioners. They were more worried about it, interestingly. They may have been stronger because they were more often in the position of framing or managing legal problems. That role may have given them a stronger sense of their own agency or control or role over how legal issues are dealt with. Because in-house lawyers were more likely to suggest they had a voice in a normative or business judgment about risky activities, their discomfort may have been higher. They had more kind of skin in the game, if you like. They were involved in the process of corporate decision-making in ways that private practitioners were generally not. And this made it harder for them to disclaim to themselves, if you like, responsibility. Conversely, this may also have given them more opportunity to influence towards good than private practitioners, who more clearly saw themselves as technicians for whom such questions they just really weren't relevant. Equally, the in-house lawyers may have just seen more behaviour of concern. Right? This sense, then, that the ethical lives of in-house lawyers are both richer but more challenged may explain why some have begun to take a more questioning position on the sector's identity and approach. I'll come back to that a little later. Okay, let me move on then to the risk study. Legal risk management, for those of you who don't know, is something of a buzzword in legal practice, particularly the in-house community. The aim is to better define, mitigate, manage, and contain legal risk. In the broadest sense, it combines professional judgment with proceduralisation, and for some, not all, a more genuine grappling with changing behaviour and evaluating the impact of risk and compliance and legal programmes. The aim is not to avoid all risk, but to embrace some, to have appetite for taking risk, and to have systems for managing it. Now, of course, professional objectivity and independence are necessary for risk assessment to be accurate and useful, but are they in tension with the pressures on in-house lawyers to be commercial team players? That's the kind of, in many ways, that was the issue we were looking at. The logic of having appetite for legal risk involves sometimes accepting, even welcoming, tolerance for conduct which may be likely to be unlawful. It is relatively easy to see how this fits with an obligation to promote the client's interests, but at what stage is the obligation to protect the rule of law engaged? At what stage is it engaged? Legal risk management is thus a fitting together of professional and commercial logics which tolerates, normalises and sometimes promotes the desirability of taking risks with law, of taking risks with lawfulness, of sometimes taking risks with illegality. It feeds the business's appetite for procedures of control, and in-house lawyers able to deliver good legal risk programs are able to demonstrate the kind of strategic and managerial capacities critical to their status within the organisation. Indeed, and this isn't a new thing, but we found it very strongly, in-houses are very sensitive to their place in the corporate network of influence. That sensitivity sometimes requires a negotiation between the lawyer's view of what is lawful or lawful and right and their view of what is tolerable. Corporate codes and commercial arguments about sustainability, short-term opportunism, were stronger drivers in that negotiation and the way they thought about that negotiation than were professional principles. When we asked them more specifically whether management and assessment of legal risk raised professional ethics issues, our interviewees broke down into three broadly similar-sized groups. The first group were those who considered that the management of legal risk did not raise ethical issues. Just wasn't a problem. The second group were those who considered that the management of legal risk might raise ethical issues in theory, but didn't in practice because they had ethical employers. Okay? And the third group were those who considered that professional ethical problems could and did and just would kind of inevitably arise. Occasionally, not very often though, there was a suggestion that such problems were fairly frequent. We can hear a somewhat qualified example of the no ethical problems here type in this quote. Again, I'll just read it. There may well be examples where the most senior lawyers are in great difficulty, but I would have thought that's because they need to do something or they don't do it, rather than, for example, I'm going to resign because no one's taking my advice. As with the professional minimalism study, you can see this lawyer seeking refuge in the comfort of hierarchy and the business not him having agency. The closest articulation of professional rule of law obligations came implicitly when interviewees talked about the concept of comfort. Interviewees talked about getting comfortable with law's ambiguity, but not allowing that ambiguity to be abused. Here they saw each piece of advice was part of a broader series of interactions where lawyers worked to persuade their colleagues of their utility, relevance and commitment to the business. This meant compromises needed to be made as part of the cost of having the legal department influence the company. Thus, one of the terrors of in-house lawyers was being perceived as difficult, and colleagues not then coming to them for advice when they ought to. If you like, information and power could evaporate at the same time as independence was asserted, or if independence was asserted a little bit too firmly. It follows that, I think, professional claims to independence by our interviewees were subtle and not naive. Independence did not either exist or not exist. It manifested along a continuum and could be weaker or stronger at different times and in different contexts. Similarly, our interviewees understood independence was sometimes in tension with their need to serve and be seen to serve the business. They had to perform that idea of service, if you like. Conversely, professional independence could be reinforced by the business if, for example, the business leadership explicitly supported legal's more independent role. So sometimes the business worked with legal to support independence in a way which might change the culture, if you like. And generally, a corporate discipline was at work that protected the discretion of senior decision makers. And that disciplined lawyers towards corporate norms. That discipline reminded lawyers that they were there to support the business, that they advise and not decide, supporting the professional logic. This corporate logic of hierarchy enforces that strain of professional ethics, the idea of non-accountability. I merely advise the client decides. You hear this all the time if you talk to commercial lawyers. Perhaps the land of SCB and the fake banks. The discipline was sometimes also more directly disciplinary. Some in-houses saw or had experienced CEOs publicly or more subtly calling out lawyers for being obstructive. Other ways, promotion, getting allocated interesting work, incentivized behaviour. In general, in-house lawyers and the businesses they worked for had an interesting allergy to the word no. The power of no should not be exercised by anyone other than the corporate the ultimate decision maker. The lawyer's role as advisor generally precluded them from being the ultimate decision maker unless the business allocated them the responsibility and power to do so. Some do allocate that responsibility. Now, I don't mean to suggest that for in-house lawyers saying no was impossible, far from it, or that advising in robust terms never occurred, but saying no was seen as a last resort. Many saw avoiding the need to say no as a mark of their skill. Saying no, if they did it, was also a process which required political coalition building within the business if it was to succeed. No could be hard and dangerous work. Discomfort and concerns about independence meant that on occasion our in-house lawyers felt their companies were taking unreasonable or perhaps untenable positions on the legality of their action. We sought to explore the outer limits of the comfort-discomfort boundary. What did it really mean? We asked them, what are your red lines? How do you define the ethical boundaries which you won't cross? We noted the following characteristics of these discussions. The ability of our interviewees to articulate specific red lines was limited, largely around that criminal kind of boundary thing. There was often no apparent reliance on either ethical principles from the corporate codes or from the professional handbooks. There was a tendency to look to the business to provide ethical leadership, just as they looked to the business for a sense of risk appetite. And there were those who indicated no red lines. I have no red lines. That's a bit risky, isn't it? One of them said to us. They were the ones who tended to say the business, not the lawyer, took all of the ethical decisions. They were simply not responsible. Now, it's fair to say that whilst professional principles were generally not called upon, professional status was perceived as useful. It helped establish a level of independence within the business and a basis for making claims on that independence and on something like the public interest. So it wasn't all bad news. So whilst lawyers and businesses project a belief in legality or working within the law, we heard quite a bit about this today, in reality this could sometimes mean something different, sometimes. Not risking serious criminal sanction. Having a defensible, if sometimes weak or risky argument that behaviour was otherwise within the law, was something which was within the law. I refer you back to the CEO on the Today programme. Sometimes such arguments were a response to conflicts between incompatible international standards, or the feeling that total compliance with complex, changing, sometimes uncertain law simply cannot be achieved. Sometimes the arguments may have been a cover for creative or selective compliance, or the obfuscation of non-compliance. In many respects, the findings then overlap with the professional minimalism piece. If, as often appeared to be the case, the limit of tolerable conduct is defined predominantly by criminal conduct, how is it professionally ethical? Furthermore, given the profession's fondness for commercial awareness, that lovely phrase, as a concept, it is interesting to note the language used in this next quote in describing the kinds of decisions in-houses were uncomfortable about. They talked about non-criminal activity sort of on the edge of commercial practice. When you're advising a course of action, that's one quote, it's a different quote. When you're advising a best course of action, which isn't criminal, it's just commercial. They can choose to ignore you and you're an employee. I don't want to decry commercial awareness, but it has within it that seed of a slightly more uncomfortable truth. The final point which I would emphasise from the risk study is the sense that there were some corporates that adopted a richer, perhaps more values-based approach to ethics and compliance. They'd seen that a minimalistic approach to legal work was an ineffective way to drive behaviour. So if any of you have read Ben Heinemann's work, he's a former in-house leader at General Electric. He's an example of exalting commitment both to the letter of the law and the purpose of the law as a key part of the policy framework for legal departments. Again, we heard a bit about that, quite a bit about that earlier today. The idea is that a commitment to stronger professionalism can support a commitment to better corporate governance and vice versa. You have to be committed throughout the company to doing the right thing, for people throughout the company to do the right thing, yeah? And that includes a maturer attitude to interpreting the law. Okay, let me turn to the fun bit, the values studies. I think this is the fun bit. If I had longer, I'd take you through the evidence that suggests that financialisation of legal practice, the business frame, the commercial awareness frame, if you like, and shallow professional frames are likely to be associated with a greater incidence of ethical problems. Okay, instead, I will focus on some work I've been doing with Rachel Cahill-O'Callaghan, Kat Denvir, and others on values. What we've been doing is measuring the values of lawyers and law students and seeking to examine potential links between their values and ethical decision-making. It's quite experimental work, this, I would say. We use Shalom Schwartz's values tools. These are widely used and well validated. The basic theory is that each person's values can be broadly understood across 10 fairly stable dimensions. Okay, show you in this graph the sort of thing that I mean. So there are the 10 dimensions around the graph. I'll explain those in a minute. The graph here, this graph compares 100 lawyers who are a mixture of commercial private practitioners and really very senior in-house lawyers. And we compare them with a representative sample of the European adult population. So the European adult population is in purple, and the elite commercial lawyers, if you like, are in pink. That's the difference in their profiles. Before I go on to criticise the profile in pink, that's the profile which looks an awful lot like my profile. My wife says I should never show my profile in public. So that's the closest I could get to doing that today. But that's the comparative profile. So to simplify somewhat, what I take from this is both groups tend to value universalism, which is essentially fairness or justice, and benevolence, the interest of our group, the interests of our in-group, or the people close to us, kindness, if you like, highly. So lawyers and adult Europeans generally value those two things highly. All of us probably generally, not all of us actually, but most of us will value those things very highly. Lawyers value self-direction, which is the ability to think things through and sometimes decide things from themselves, much more highly than European adults generally. They also value stimulation and socially recognised achievement, people thinking they're competent, more than European adults generally. And they value power, perhaps a little bit more. Power overlaps strongly with economic status. They also, kind of surprisingly to some, seem to value security, tradition, and conformity a good deal less. So lawyers perhaps aren't quite the stick in the muds that we sometimes portray ourselves as. Okay, so what? Schwartz predicts and has demonstrated with other research that some of these values are more or less associated with ethicality than others. So universalism and benevolence, justice and kindness are the most pro-social values. Yeah, surprise, surprise. Achievement and power are the least pro-social values. So achievement and power are most likely to be associated with unethical conduct. If you value conformity, tradition and security, then you probably, Schwartz thinks, more likely to be ethical. He's a bit less sure about self-direction, stimulation and hedonism, probably a bit more associated with less ethical decisions. Okay, that's what the theory says. Okay. Now, my interest in this is not really to set up some kind of deterministic causal link between values, particular environments, and behaviour. What I am interested in is whether lawyers from different types of practice, law students heading into different careers and so on, have different values, and whether those values are the result of students and lawyers picking the environments that suit them or the environments shaping them. So, for instance, we did find in looking at the values of the elite lawyers that those lawyers in private practice who worked in highly regulated sectors had somewhat different value profiles from those who worked in less regulated sectors. The private practitioners working in highly regulated sectors valued justice and conformity significantly more highly, and indeed tradition significantly more highly than the lawyers working in less regulated sectors, which is of course what you would predict. Are they being shaped by their environments, or are they choosing to gravitate towards that kind of work? I don't know. I just think it's an interesting question. More interesting again is the question as to whether a person's values may influence their decision making. No, I say influence, not cause it. So in doing this work, what we do is give our respondents ethical problems to deal with. One is a problem where a lawyer is asked to advise a company on how it should handle transactions over dual-use items to a rogue regime. For those who don't know, dual-use items are engineering items that can be used for either innocent purposes, but also to make weapons, hence the dual use. They are told that they advise the business that these transactions are highly likely to be unlawful, think sanctions busting. They are then asked this: prior to the company deciding what to do, should you also advise the client on how to handle the transactions so the regulator is significantly less likely to scrutinise them? Yeah? Think wire stripping. That's what I was modelling on when I was thinking about it. Now, I've conducted this experiment with a number of groups of lawyers, and generally about 1 in 4 say they would give the advice that enables their clients, helps their clients, if you like, to cover up the illicit transactions. Now, the interesting question is, for me, is not so much whether this is the right or wrong proportion or the right or wrong answer, but how the values of these two groups might differ. So what we discover is that those more inclined to help cover up the illegal transactions on average value achievement and power significantly more highly than those who say they would not do so. So it's, on average, it's the 5th most important value to the group who say they would provide that advice. Achievement drops down significantly for the group who said no, but it's not in the top 4, so it's not the dominant thing that they value, but there seems to be some relationship between their decision and the values. So what, again? Well, in doing this question, I'm often using the survey as part of a training experience for the lawyers. It helps open their minds, I think it does anyway, to their own subjectivity. Decisions up to a point are, it seems, a matter of personal preferences, sometimes subconscious personal preferences. But I think it's also of interest because if we see legal practice as increasingly emphasising power and achievement as values to be promoted, we can see how we might be reinforcing these values and influencing decisions in a riskier direction. At least I think we can. The third point for students of zealous advocacy is that the traditional claim for zealous advocacy, if it were correct, then we might see different results. Proponents of zealous advocacy claim a kind of selfless putting of the client before all else. Yeah? Yet, at least in values terms, the most zealous lawyers that we saw here were the ones who were most likely to have strongly self-interested values. Power and achievement is about the self, it is not about the client. Okay, I want to quickly mention, just because I'm quite excited about it, we're doing a similar study on 1,000 law students, essentially looking at the issue of whether law students' ethics degrade through law schools. So academics agonise about us making them worse. Do we do that? And do law students heading in different directions have different profiles? All I'll say is, buy me a drink later and I'll tell you all about it. Okay, conclusions. So what should I say by way of conclusions? Firstly, I think there's potentially a serious problem. I don't know for certain there's a serious problem, but I think potentially there is. I think a broad raft of evidence points in that direction. The list of corporate problems I spoke of at the beginning point to the capacity of firms, often held out as the best firms, to make mistakes. Yeah? And I don't really do that to beat them over the head, although it's sort of fun to do that. I don't think these are bad firms, far from it. And I don't think probably these are bad Apple lawyers. Right? I think they probably made bad decisions. And if they made bad decisions, they can probably be trained, possibly regulated, and certainly better managed away from that. I certainly like to think so. Again, it speaks to what Joan was talking about earlier. Equally, I don't doubt that I sometimes overstate or simplify, and it's important to remember that ethics is not the only logic to be attended to. Efficiency, creativity, and innovation are all important, but their importance equally does not mean there is no work to do on ethics. Secondly, I think there's some appetite for change. I sometimes get criticised giving talks like this, particularly when there's lots of practitioners in the audience. But equally, when I get some criticism, I tend to get quite a few approaches afterwards from practicing lawyers where I get quite interestingly insistent support. Colps and in-house lawyers are particularly willing to engage in this way, I find. So the Ethical Leadership Initiative for in-house lawyers, which Paul Gilberts, Stephen Vaughan, Stephen Mason and I have recently launched, hopes to tap into some of this interest. We're starting a major survey with in-house lawyers to stimulate, we hope, an in-house lawyer and evidence-led policy debate. Thirdly, many of the concerns I've mentioned are, I think, concerns also generally for corporate governance. They're not just professional problems, again, as Celia and Joanna, I think, were saying earlier. The question for corporate lawyers might be reshaped as not how should I put the client's interests first, but how should I put the interests of good corporate governance first, or well-functioning markets first. There are shared interests with those working on banking standards, for instance, and the like, which are not best served by superficial claims about the superior professionalism of lawyers. I've seen some really horrifying things said to banks about how brilliant lawyers are, completely without any recognition of the kind of SCB, Lehman Brothers kind of problems. Those interests involve, I suspect, a clearer articulation of the expectations of lawyers advising corporations and the challenges it brings, both for in-house lawyers and for private practitioners. It's also, I found, this is a recent eye-opener for me, really interesting to hear what compliance officers and their ilk think about what lawyers do, what they think approaches to independent investigations, legal professional privilege, and disaster management should be. They don't think lawyers are good at it. They don't think they act in the interests of the company often. It will be doubly interesting to hear, for example, what non-executive directors expect and want from lawyers. That kind of research should be done. Fourthly, the Code of Conduct is hopelessly silent, as we've heard, on the problems of commercial practice, and its principles are seen as either irrelevant or unchallenging. There are, of course, neither, but work needs to be done to change that. Finally, I promise, ethical leadership in firms. With some exceptions, I would say ethical leadership in firms is probably generally pretty weak. I'm going to leave you in a minute with one last quote. Whether you think I'm right or wrong about the specifics, I'm going to emphasise that we need to talk about ethics more, we need to teach it more and better, and we need to research it a whole lot more, I would say that would line. And firms need to manage it better. At the moment, too many of them assume they recruit the right sorts of people, and they've had the training on this in the LPC, and that's enough. Don't all do that, but too many of them do think that. Let me give you a counter to that particular perspective. It came from an associate in a leading law firm. I don't think I've ever come across any support or encouragement on the ethics front. It's assumed that you've gone through your ethics training and you are meant to know it all. Nothing has ever, really ever, been said to me from the partners or in terms of training that in any way encourages it or supports it. Professional minimalism. I think it needs to change. Thank you very much.